High Court cannot step into the shoes of the trial court and try to usurp the jurisdiction of the trial court, and cannot stoop the status of the High Court to a lower court level by indulging in appreciating evidence provided by the accused. So, in that context, in 1974 to SCC 615, Supreme Court has observed that it is not for the High Court to discuss the evidence and come to a conclusion different from the conclusion arrived by the trial court. The High Court, while exercising its power under Article 227 of the Constitution, was not entitled to discuss the evidence given and to come to its own conclusion on the evidence, and if this is permitted, then it would clearly amount to overstepping the limits of power under Article 227 of the Constitution. When an order on charge is assailed before the High Court under Article 227 of the Constitution, and it is stated that it was a fit case for discharge of the accused, in fact, the prayer made to the High Court is invariably to scrutinize the evidence collected and come to a conclusion different to the one arrived at by the trial court. Again, in AIR 1958 SC 398, Supreme Court has held that the powers of High Court under Article 227 of the Constitution are not greater than the power under Article 226 of the Constitution. It has been further laid down that power of interference under Article 227 of the Constitution was limited to see that the subordinate court and tribunal function within the limits of their authority, and High Court cannot sit in appeal against the order of tribunal under Article 227 of the Constitution. Again, in another case with reference number AIR 1963 SC 1895, it was laid down by the Supreme Court that jurisdiction conferred by Article 227 of the Constitution was not by any means appellate in its nature for correcting errors in the decisions of the subordinate courts or tribunals, but was merely a power of superintendence to be used to keep them within the bounds of their authority. So, umpteen number of cases decided by the Supreme Court have clearly mentioned that under the cloak of Section 482, Article 227, an accused cannot take rescue for delaying the trial, and an accused cannot ask for reappreciating the evidence provided by the complainant in the lower court, and a High Court cannot indulge in appreciating the evidence of the accused. Such kind of petitions which are filed for the purpose of delaying the trial are stated as the litigations of perversity which are raised only to get the petition admitted. There, the issue of jurisdiction is rarely involved. The perversity of a lower court order can be argued in respect of any well-written judgment, because perversity is such a term which has a vast meaning, and an order which is not considered by the litigant in its favor is always considered perverse by him and his counsel. Therefore, if a counsel approaches High Court under the guise of perversity of the lower court's order through a petition under Article 227 under 482 CRPC on a lower court order, that would amount to doing indirectly the same thing which cannot be done directly, that is to say, delaying the trial as the main intent of the accused. And I consider that no petition under Article 227 and Section 482 can be entertained for such kind of frivolous, time-dragging tactics used by the litigants. Hope the information is quite useful to you all. Thank you very much.